Next stand, please. An appeal in the matter of Lazari Properties 2 Ltd and others, and New Look Retailers and others.
Yes, Mr. Arden.
Please, Your Ladyship's Lord. In this matter, I'm here with Mr. Shaw for the appellants, and the learner friend, Mr. Al-Attar, appears for the respondents. Mr. Al-Attar just asked me to mention to you that he's waiting for his robes. I'm afraid the queues outside were rather long this morning. But
Not at all. We hadn't even noticed.
But we thought it best to crack on.
That's the tube problem, is it? That's created a great big...
It was difficult to say. The number of staff looked the same, but it was an extraordinarily long queue.
Oh, well done for making it.
Right. Thank you very much. The court should have received, I think, last night,
yes,
confirmation that the settlement in this matter did complete eventually yesterday evening. And there is a very short and simple order, which again I hope you've seen, which simply in 2 paragraphs provides for the disposition of the appeal, dismissal with no order as to costs.
Yes, we received that. In fact, the 3 of us received that at, I think, shortly before 9 o'clock this morning. But it did, I know, reach Miss O'Dwyer at about 9:36 p.m. last night.
It was late. I think that was the 3rd attempt at completion yesterday.
To email it?
No, just simply there were 3 completion meetings yesterday. The 3rd was successful.
Yes.
The first 2, 1 document was still outstanding.
I see.
So I think so far as the appeal itself is concerned, we'd simply invite the court to make an order in the terms that have been provided, in the terms of the draft that's been provided.
Yes.
And then there's a separate matter which I need to address you on, which was raised in an email to those instructing both of us yesterday afternoon.
Yes, we will just for the sake of formality, formalise and approve the consent order that you have submitted in the terms that have been submitted. I will amend it to add the names of the Constitution.
I'm sorry.
No, it doesn't matter at all. And sign it accordingly. Make sure you have a hard copy of that before you leave, Mr. Arden.
I'm very grateful.
Yes. Before you address the chronology, and thank you for being in a position to do that, I hope that you will understand where this is coming from.
Yes.
Obviously, the timing of the settlement, commendable though, of course, any sensible commercial resolution is, causes the court and has caused the court very significant disruption. Obviously, we are fully prepared for a 2-day hearing. That's a substantial matter with substantial papers. We were asked as recently as 4:30 or 4 o'clock yesterday afternoon to maintain that listing, with which request we complied. What concerns us, and you may be able to help us here, is that permission to appeal was granted by the judge himself back in May. Skeleton arguments in May and October of last year. This hearing has been fixed for a long time. We understand that there will be complexities in sorting out major litigation like this with numbers of leases and all the rest of it. But we don't understand at the moment why it has happened so late in the day with the consequences that we have just described. So that's what we'd appreciate some assistance with.
Well, lady, obviously haven't been directly involved in the negotiations. But
when did they start?
The lady, the negotiations started several weeks ago, and my instructions that they essentially they were in a sense staggered. One set of appellants, it started with one set of appellants and then extended to all appellants.
Well, two groups already settled some time ago, didn't they?
That's right. So it's the Traffords, what we call the Trafford
yes.
Centre, settled some time ago. In fact,
yes.
They never settled some time ago. That left the British Land and Landsec appellants.
Yes.
If I've understood this correctly, the negotiations started between British Land and the respondents first, and then Landsec Securities joined in about a week, I think about a week or 2 weeks later.
Just to press you, when did these negotiations first start? Those involving these two categories of landlords.
In terms of the, what I can tell you, I think, is this. I'm not sure when exactly they started, but I do know, my instructions are that the negotiations started, I think, in a sense, with at a very high level. There's obviously a great deal of detail that then needed to be sorted out. But in terms of, I can tell you that the first the first set of agreements, you'll understand that there's obviously a significant number of properties that have had to have been dealt with, and each one had to be the subject of separate negotiations.
Can you just remind me how many?
It's 37.
Thank you. Yes.
And the first set of heads of terms in relation to a specific property were negotiated and agreed in the case of British Land on the 22nd of January, and in the case of Land Securities on the 4th of February. So that's just, I mean, I should say before then there's obviously a commitment to negotiate. And Milady, I think it's probably right to say that there would have the broad parameters of the negotiations would have been agreed before that. I'm afraid I can't tell you exactly when negotiations started as in relation to those which led to the agreement about the broad parameters of the negotiations, if I can describe it like that. The best I can tell you in terms of detail is what I've just given, which is when the first heads of terms were agreed in relation to specific properties. And since those two dates, essentially what has happened is there's an overall settlement agreement, and then separate negotiations and heads of terms were then agreed for each of the 37 properties. And those negotiations and agreements have been an ongoing process from the 22nd of January up until effectively last...
I mean, speaking for myself, and I will ask whether my colleagues have any questions of their own, it doesn't surprise me that it's taken in the order of a month to get where you have got to. What I don't understand at the moment is that, given that that sort of time period would always have been, if not a minimum, then a useful, informed guess, why this process didn't start so much earlier. You know,
I think that I'm in more difficulties with.
That's the concern of the court, I think.
I'm sorry, that I'm in more difficulties. I can I've given you the sort of the firm date. I took instructions, but I focused on I think focused rather more on the process, so that I could tell the court how the process has worked.
As I say, so I don't think we need. We understand that the structure that you've helpfully outlined for us, and no doubt there's been a lot of very hard work, long into the night, between, say, the mid to end of January and now. But I think the message the court wants to send out in cases like this, where there's a heavy appeal listed, is that these sort of discussions need to happen much, much earlier, so we don't end up at 20 to 10, the night before a 2-day appeal hearing, being told that the appeal is not going to be effective. That's the message I think we really want to send out.
Well, lady, I think I'm looking behind to see if I can give you a better start date than I've been able to give you so far. It was
obviously a very full hearing, a very full judgment, extremely talented teams on both sides, excellent skeleton arguments. At the very latest, the respondents had got their head round your case by the time they put their skeleton in October. That was the time, at the latest, when this sort of exercise should have been really brought to the fore and focused on. And we wouldn't be here now.
Lady, I understand what your ladyship says. If you want, I can take instructions as to when.
Yeah, if there's an easy answer to this, there's a reason why nobody could focus on settlement before, earlier than happened, then by all means tell us. But other than that, I mean, that's, I think, what we wanted to convey this morning.
I think I won't be able, the best I'll be able to do, if I can do it at all, is to tell you when collective minds address settlement, which
Yes.
will obviously be earlier than the dates that I've given you. As to...
There was never a mediation under the Court of Appeal mediation scheme or any other mediation process.
No, you'll appreciate one of the difficulties of this case is that it has been seen as something of a test case.
Exactly.
And so...
I understand why.
So it's less obviously a mediation case,
Yes.
or case where
Yes.
mediation is likely to
Yes.
work. I think what has happened is, and probably not the first time you've been told this, as the appeal has got closer, minds have turned towards the possibility of settlement.
And you put your finger on it, Mr. Arden. It just needs to happen earlier.
Lady,
The imminence of a hearing is no good reason. You know, this is always going to take a lot of time to sort out.
Lady, do you want?
Please,
shall I just
of course,
quickly
Mr.
if I can
Arden. Please do.
just take a moment.
Anything you particularly like? Yes, yes. And I can see why this wasn't a mediation case, actually. It was a test case. We didn't expect it. I didn't expect it to settle.
I can take it only a little further. I think the problem I have is that I'm instructed that the first contacts were between clients, and that those instructing me were instructed in relation to settlement fairly shortly before the dates that I've given you, without going back to the clients.
No, I understand.
Asking
All right.
for more
Well, thank you.
details. I don't think I can take this much further.
Thank you.
The only other thing I was going to address, I mean, your Ladyship very kindly identified the difficulties in trying to do this sort of settlement, and your Ladyship is right that the process was a difficult one. All I was going to say, or what I was going to say, was just to address just to explain in a little more detail what the last 7 days or so have involved, so that the court can see how we got to a point where settlement was only achieved yesterday evening. And it is essentially this, that when the first letter went to the court on Wednesday of last week, Tuesday, I'm sorry, of last week, that the position then was that the parties were hopeful and I think cautiously optimistic that this would settle, but all of the agreements were not then in place. They hadn't then been finalised or approved.
Yes.
That the process of approval, it was obviously hoped that we could have done all of this by the end of the week at the latest. By Friday, by the end of Friday, all of the agreements, the agreements were both, the agreements had been agreed and approved. And the approval process itself was quite complicated because, as you'll have seen, the properties are held through nominees. So it's not just British Land or Land Securities saying yes. Certainly in all of the cases of surrenders and regrants, the consent of asset managers had to be obtained as well. But all of that was achieved by the end of Friday. But what was missing was execution. My instructions are that, as at the beginning of yesterday, it was hoped that execution would be fairly straightforward, and the process had been lined up but as at the beginning of yesterday, the 11 leases covering 12 properties where there was to be a surrender and re-grant were still awaiting execution. And it was unclear yesterday morning quite how long the process was going to take. Most of it was done, it could be done electronically, but it still required the boards of the nominees to go through the process. Electronic signature was available in most but not all. In at least one case, wet signatures had to be provided. That's the term I'm told is the right one. And that was a process which, collecting in the executed versions, was a process which essentially wasn't complete until about 8 o'clock yesterday. By the end of yesterday, there were 2, and then 1, and then the last one came in very, very late. I think that taking that long, I think, was not expected. I think we thought that it would have been done much earlier, and indeed by Friday. There was much less clarity yesterday about how the whole process, or how yesterday would go, and whether we would need to. There was a suggestion, well, perhaps we should ask the court to sit later and just give us the extra couple of hours, in the event that wasn't required. But that's essentially how it, or what happened.
I understand. Well, that's very helpful,
yesterday.
and thank you for filling us in. As I say, the real concern is not what's been happening in the last few days and weeks, but really why it started so late in the day, particularly where there was obviously settlement with some other groups. If it was ever going to be an issue, a possibility, it's just something that the parties should have turned their minds to much earlier than appears to have happened,
I do
to avoid
understand
this situation.
I'm sorry I can't give you
That's fine.
more of the detail that I think your ladyship.
And I think the other important factor is when it gets really, if I can put it this way, so close to the wire, that communication with the court, if necessary directly with clerks, is also something that can be very helpful, particularly overnight. So my lord, my lady, my lord, we didn't know that there had been settlement until this morning, even though you did email Miss O'Dwyer at 9:36, by which time she had not unreasonably logged off. So I think that's just something else to bear in mind. You, I know, will understand how much work goes on this side of the bench in preparing for these hearings and allocating responsibilities within the Constitution. So that's another important factor. But thank you very much indeed, Mr.
Can I just
Garden.
say in relation to that, I think I take some responsibility for this, because firstly, I'm not sure that the Friday emails
Went to everybody's
got
clerks.
to the court, and having already sent your ladyship's clerk directly the Tuesday letter because there had been a problem with the bundles, I should have but overlooked that it would have been sensible to have done exactly the same thing on Friday, although I don't think we would have known every clerk to send it to, but at least we could have sent it direct to your ladyship's clerk. And we were very conscious yesterday morning that something needed to be said. The problem was just trying to work out quite what it was, what we could sensibly tell you. I think obviously something came eventually, but it shouldn't have taken your ladyship's clerk. We shouldn't have needed a chaser, or we should have got it out before the chaser. And I'm very sorry for that.
No, well, that's kind. I mean, we're not so long in the tooth this side of the bench that we don't remember what it's like being at the bar and at the coalface of complicated negotiated situations like this. So it's clear to us efforts have been made, and the court has been in everybody's mind. But as I say, we shouldn't really be here at this late in the day standing down a 2-day appeal, and to emphasise the need for that direct communication with the Constitution's clerks if it really becomes something that is happening so late in the day. Before we call on Mr. Alatar, could I ask you a different question? But I noted in your instructing solicitor's email that there have been difficulties accessing CE filing on some appeal numbers, was the reference given. Now, as I say, simply for our information, could you give us some detail on that? Has there been a problem, and if so, what has it been?
I saw a reference to it on Friday
Yes.
night, I think it was.
Maybe your instructing
Can I
solicitor could
take
just,
instruction?
if possible, don't worry if not, it's simply for our information to, as we gather experience under the new CE filing system.
if your lordship wishes to hear from Mr. Alatar, and then I will take instructions on this point and come back to you when he's finished, if that makes sense.
Yes, Mr. Alatar, anything you would like to add?
My lady, firstly, apologies on the part of Mr. Smith, who's unable to attend this morning and has had a release from my clients. It's owing to the fact that he and I are both involved in a long-running case on which an urgent injunction has arisen. And so we've unfortunately had to split our teams. So you've got the understudy this morning, for which Mr. Smith apologises. The matters I would like to assist you on, with your leave, are from the company's perspective, understanding why action was not taken sooner and why the court may be able to have notification earlier as to the settlement. Can I give you some dates in that respect, picking up from where my lady left off with Mr. Arden as to the filing of the respondent skeleton on the 1st of October?
Yes.
Following the 1st of October, there was then, appears to me, a gap in the chronology that I've been given. The heads of commercial terms were agreed with British Land contingent on the lease negotiations on the 10th of December. 4 days later, there was board approval from the company for an in-principle settlement with British Land. I pause there because there are essentially two credited constituencies. There's British Land and Land Securities. The settlements, on my understanding, were not inconditional, but had either one failed, the appeal would have been fully live on all issues. So in essence, there are two twin tracks of negotiations. So British Land started the process, and the parties, in principle, subject to the detail of the lease negotiations, had some sort of agreement before Christmas. There was then the lapse of the Christmas period and January, and it wasn't until one gets to, I understand, the 11th of February, that commercial settlement terms were agreed with Land Securities. So we'd got to essentially the middle of the last month before we'd reached heads of terms contingent on the lease negotiations with Land Securities. So in effect, the settlements being depositive of the appeal has come about in the past few weeks, albeit in saying that I have recognised that there was in the timetable essentially a gap between October and December when the parties might have come to terms sooner. After the 11th of February, I understand that on that day, conveyancing lawyers were instructed in the relevant jurisdictions in respect of both British Land and Land Securities. Now I've not seen the settlement terms, and I understand they're confidential, so nothing I can say is about those terms. But you can see from the structure of the settlement that where value may have been given up or taken, it appears to have been in the lease negotiations. So in this instance, the lease negotiations are not just a formality.
No, I understand.
You
say that they're the meat of the sandwich.
Exactly. And so what transpired then is a negotiation of the lease agreements. And it looks like on the 16th of February, the board approval was given in relation to the Land Securities settlement. And then from that time onwards, the settlement negotiations took their course. Now, what that does mean is that the court was first notified, I think, on the 22nd of February. And the question, it's not for me to answer, I can see why the court may wish to say that it should have been notified at that point. The only thing I can offer is that there's a difference between the parties making a judgment under the practice direction as to whether the settlement, as to its detail, is sufficiently progressed. There's a judgment there that I can't assist the court with, I'm afraid. That's all I wanted to say.
Well, thank you very much indeed. Thank you, Mr. Alice. I've got no questions for you. No, thank you very much indeed. Thank you. Yes, Mr. Arden.
I'm grateful that actually Melanie Francis addressed a point that I couldn't, which is helpful. I knew that the negotiations were staggered, but I think he's put a bit more flesh on the very little that I was able to offer up. I was just going to mention, in relation to the CE filing, as I understand, there's not a fundamental difficulty. I think the difficulty in this case just revolved around the appeal numbers. And I think, I'm not
Being
sure.
what? That you couldn't, you put the numbers in and...
Put the number in and the system didn't recognise
So
it.
what did you have to do? Put in
it
a different number?
It was given a different number. It was given a different number, and
Right.
once we had the different number, then we were able to file.
And how did you get the different number? Did you have to email and ask
The
somebody?
court gave it to us.
So I see you said we can't access for some reason,
Yeah.
and then you were given a different number. Okay, well that's...
I understand
Good.
that. The new system has completely renumbered every appeal. So if it was a pre-CE filing appeal, it would have been given an A number or a B number. I think it was an A number, an A2 number, and it would have been given a completely new number for the purposes of CE filing. And unless and until the parties were supplied with that number, you wouldn't be getting access to it. So I understand that.
Maybe
Thank you very
that's helpful, and we're forewarned for any other case that might fall within the
Yes,
bracket today.
if it was given an A number, a B number, or a C number prior to roundabout Christmas, the new numbers all begin with a C, confusingly, and they all have the year of the filing. So they would be something like C1 2020, and then XYZ ABC, whatever the number is. But I've had to deal with this quite a bit because of the county court appeals that I have responsibility for, and a lot of them have changed, and it's caused great confusion in the filing. So I have some sympathy for you.
Well, maybe that's helpful to know, and that will get back to those instructing me so that they can deal with it, or they can anticipate it before it becomes a problem. Thank you very much.
Thank you both. Thank you all for coming to court, and thank you to those sitting behind you as well. Here is the signed hard copy settlement order. If I could just ask the court clerk, please. Thank you. To hand this down to you. And I think all that remains to be said is that we all enjoyed very much reading the skeleton arguments on both sides and considering the issues, which were of great interest.
Lady, thank you. I'm sorry we couldn't
Yes,
give you
well,
the opportunity
yes.
to conclude.
Thank you very much indeed. Is there anything else, Geraldine?
No.
Thank you all very much.